Court. I'm Ruth Greenberg, and I'm here for Mr. Michael Hart. I'd like the Court to look first at my argument under Commonwealth versus Brown, which I do believe is dispositive of this case and maybe the only three-page winning argument in the history of this Court. Brown is a bright-line rule. Contrary to what the Commonwealth asserts, it is a bright-line rule. Witnesses don't have any obligation in the Commonwealth to speak to the police. And the fact that witnesses know they don't have to speak to the police means witnesses know their rights. Before a prosecutor can ask a jury to draw the conclusion that the witness is a big fat liar because he didn't talk to Bobby Murner, a predicate has to be laid. And the burden is on the Commonwealth to lay the predicate. I could find no case that said the Commonwealth had to lay the predicate beyond a reasonable doubt. In fact, I saw no standard. But it's clear that the burden is the prosecutors, and I would say it should be beyond a reasonable doubt, and it ought to be at least by clear and convincing evidence. Yes.
Are you claiming that all the factors in Commonwealth versus Brown were not met, or just that the fourth factor was not met?
The factors that were not met in Commonwealth versus Brown were the fourth factor, that the defendant and his lawyer or both, but also the second factor, that the witness had reason to make the information available. And that's the reason I gave to you, and I'm sorry it's late, Massachusetts Superior Court Criminal Practice Manual, Section 8.3.5, 2008, which says what every defense lawyer worth his salt knows, that when you speak to the witnesses, you cannot say to them, don't talk to the police, but it is perfectly appropriate to advise them that it is not necessarily in the defendant's best interest to talk to the police. And every defense lawyer that reads the Massachusetts Superior Court Criminal Defense Practice Manual knows you should say to the witness, it is not necessarily in Mr. Hart's interest to speak to the police.
Well, I think the Commonwealth argues in its brief that that the witnesses were aware of the charges. Well, that's a given, just about, and that they possessed exculpatory information.
And they were certainly, that's correct. And they were certainly familiar with the means of reporting it to the proper authorities. The defendant, being a first-degree murder, is appointed counsel at arraignment. The alibi witnesses, clear from the record, spoke to the defendant's lawyer. And I think we could infer that the defendant's lawyer said to them, it is not necessarily in the defendant's best interest to speak to the police, because it isn't. And the defense lawyer knows it, and the defense lawyer is permitted to say so. And the burden of proof on point number 2 is not on the defendant to establish that this was not so. If the prosecutor
That's
wants...
point number... Isn't that the fourth factor?
No, that's 2. That the witness had reason to make the information available, because after the witness...
But wouldn't I know the Brown factors, but I'm not sure I've always agreed with them, because isn't that sort of contained within knowing that it's an exculpatory story? Because if you know it's exculpatory, that would give you a reason to make the information available, because you would want to exonerate your friend, boyfriend, son, whatever.
But I'm saying the opposite inference is equally true, particularly where the defendant is represented by counsel. That is, you don't have a reason to go speak to the police by yourself when the police call you when you have exculpatory information. You go to the defendant's lawyer and you have a reason not to speak to the police, because it is not necessarily in the defendant's best interest for the witness.
Well, how would this play out? I'm trying. If the prosecutor says, you knew you possessed exculpatory information, she says yes, you had reason to make it available, she would say, I don't know that I have to. She would say, in the vernacular, what we in court would say, I would like to rest on my rights, and I brought the matter to the attention of the defendant's counsel, and I was instructed that it would not be helpful to the defendant for me to speak to Detective Murner. That would be really what both these witnesses said. And if they had been permitted by the prosecutor to answer the questions, they would have explained it. But if you read through the
And wouldn't that
cross-examination,
by itself reflect
Yes.
that they were biased in favor of the defendant, that they're prepared to help the defendant as opposed necessarily to speaking the truth and helping the police find the right person? I mean, if you say, I want to help the defendant, well, if a witness were to say, I want to help the defendant, doesn't that go to the issue of the witness's bias? Because he said he wants to help one side as opposed to the other.
it might, Judge. There's no question that it might. It also might go to, I spoke to the lawyer, but the court has set forward what the prosecutor has to prove before they can say the witness was just not relying on his right not to speak to the police.
Okay, so what do you say the second factor means? I had thought the second factor means that the witness understood that the information that he had could reflect that the police had arrested the wrong person. You're saying it means something else.
Yes, it means he had a reason to make it available. What reason might that be?
And isn't it generally perceived as reason enough that the wrong person has been brought to trial for a crime he did not commit?
I think a witness would be correct in saying that when that's the case, that's the defendant's lawyer's job to take care of it.
But if the witness knows that the defendant is charged with a crime, it would seem to me that as a matter of law, that's sufficient to know that he had a reason to make the information available, particularly if it's murder. I mean, wouldn't that be a reason to make the information available? At least sufficient to get over the hurdle of establishing that factor.
I won't quarrel with you, Judge. I'll go to point 4, but I would say differently. The witness makes the information available when he notifies the defendant's lawyer. The defendant's lawyer presents a notice of alibi to the prosecutor's office and to the court. The information is thus made available. It is not, as the prosecutor portrays it, that these witnesses kept it a secret till the last minute or held out on anybody. These witnesses did what they were supposed to do.
Well, just for purposes of admissibility, I'm wondering if the foundation is met, at least as to that factor, by establishing that the person knew that they had exculpatory information and that the defendant was charged with a crime, such as murder, and then would it be on the defendant to show in cross-examination, well, is there a reason that you didn't make it available?
Judge, the case law that we have places no burden on the defendant.
I understand. That's why I'm asking if it would be
Right.
sufficient at least to...
No. The Commonwealth has to say, did you have a reason to make this available? And if the person answers no, the foundation is not laid. And the prosecutor...
Well, bearing in mind that we're dealing generally, it wouldn't be cross, it would be cross to begin with and then redirect. But bearing in mind that the Commonwealth is generally dealing with if not a hostile witness, an unfavorable witness. And you tend to put the questions in a very limited fashion. I wonder if too much of a burden or an impossible burden is not being placed on the Commonwealth.
It is the law, Judge, at least so far, and at least it was at the time of this case. And it was not, it didn't mean the defendant was guilty. Speaking most practically, when these two witnesses go to the defendant's lawyer and say, we are the alibi witnesses, the lawyer says to them, it wouldn't help him for you to go in. And
What
the
about
lawyer
notice
says,
of alibi? What
the
about the
lawyers-
rule that requires notice of alibi?
That's right. The lawyer gives the information, not a person dealing unmediated with the police. That's what the notice of alibi does. The notice of alibi means these witnesses are not keeping themselves a secret. They are having a mediated relationship with the prosecutor's office where they do come forward, they give their names are provided, they just don't have to talk to cops by themselves if they don't want to. You have a particular difficulty here in this case where it looks like Detective Murner is actually having a problem with a sequestration order. Here you have the prosecutor drawing an inference of guilt from a witness in the courthouse who's been instructed, don't speak to other witnesses, And then the other witness in the case comes up and says, talk to me, and he says no. And again, when he tries to explain it, the prosecutor cuts him off. Every time these witnesses try to say why the 4 factors of Brown don't apply here.
That interchange was not, maybe I'm wrong, was that during the trial itself or during some pretrial proceeding in the case?
He says, I was here last week on this case.
Yeah, but that doesn't necessarily, I'm just saying, you know, the sequestration order comes during the trial. You may be right, I just don't,
Okay,
I did not.
It's during the trial.
It was during the trial,
Yes.
okay.
Was the judge, did the judge give the witnesses an opportunity to explain their answers?
No, the DA cut them off.
Did defense counsel make any request for the witnesses to be allowed to explain the answers when the DA was saying yes or no, yes or no?
No, he did not. That's why I've briefed this question as the ineffective assistance of counsel. Defense counsel was clearly asleep at the switch. No offense to Jack Miller. But I have briefed this as an ineffective claim, and I also cite in my brief to Commonwealth versus Rivers, which stands for that's 21 Mass App Court 645, it's in the brief. It stands for the proposition that the judge is without discretion to admit this evidence unless the predicate is laid. So even where the defense lawyer is asleep at the switch, the judge still can't let it in. It's very important. I was here the last time, actually, I went on a 3-page argument, was Commonwealth versus DePace in 2001. That was a case where there was no objection, but the Commonwealth put in evidence that the defendant embraced his right to silence and played it up in front of the jury and argued it in closing. And we know that there's a federal constitutional right. You can't say just because the defendant didn't talk to the police, he's guilty. In Massachusetts, we say witnesses also, if they don't talk to the police, that's not a reason that the defendant is guilty. And that rule was violated here, and it's a clear rule. You can't say just because they refuse to speak to the police, the guy is guilty, and they're lying, because that's not the appropriate inference. The appropriate inference to draw, unless there's special circumstances, is if a witness doesn't talk to the police, that's because people don't like to talk to the police. And people have a right not to talk to the police, and the prosecutor can't say these people are liars because they don't want to talk to the police. These people are clearly, from this record, have had no positive interaction with the law enforcement community.
I think that's
These
fair to say.
people use the vernacular. They say, I don't have to talk to the police. I know my right. I don't know that I have to. I don't want to incriminate myself. They are clearly trying to explain, we know we don't have to talk to the police. And they don't. And the prosecutor, not by beyond a reasonable doubt, not even by clear and convincing, set out that the predicate that's required before their refusal to speak to the police is anything but a citizen resting on his rights.
I'm not saying that I disagree with you, Ms. Greenberg. I've had trouble with these factors for a long time, and I've been very familiar with them. But I'm wondering if the factor that you're discussing isn't somehow interwoven with the 4th factor, that the defendant or his lawyer or both did not ask the witness to refrain from doing so.
It
Because
is interwoven.
Isn't that really what you're getting at? That when the witness told the lawyer the alibi, the lawyer says, you don't have to go to the police, but it's better that you, whatever they said, and I will notify the police of the prosecutor of this information.
It is interwoven, and it is certainly interwoven. And like when we look at Miranda requirements and we say, well, these people have familiarity with the criminal justice system, these people have familiarity with the criminal justice system even before they spoke to the lawyer. They knew it's not a good idea to speak directly to the police because, as they say, everything they know, everything they say will be used against them. They have every reason not to let police into their home. That's just that's the state of the world. And that's the rule under Commonwealth versus Brown. And I want to say most respectfully to Justice Cowan, in terms of the law being the teacher of man, if we're going to change this rule now and say to people, if you're an alibi witness, if you don't go speak directly to the cops, not through the defendant's lawyer, not through notice of alibi, but if we're going to say to the community at large, we're going to say your guy is guilty unless you personally go alone to the police station and talk to Bobby Murner, we had better let the community know before it's the law. Because right now, under Commonwealth versus Brown, they thought they didn't have anything more that they had to do. So if we're going to make a different requirement, if we're going to say we're going to find your brother guilty because you didn't go alone to the police station, we had better let them know. And Mr. Hart shouldn't be the person that suffers here from what would really be a change in the rule. Because what the rule is now is talk to the lawyer. You don't have a reason, and particularly after you talk to the reason, you don't have a reason to go alone to the police. You have every reason not to go alone to the police, particularly with your experience in the system. And that's really the argument. The second question here is harm.
Okay, let's go to this fourth factor.
Yeah.
Would it be ethical for a defense lawyer to tell an alibi witness that you should not speak to the police?
You should tell the alibi witness it is not, it's...
Okay, try my question.
Yes.
Would it be ethical to say so?
It would not be ethical to say you may not.
Okay, but the fourth factor is that the lawyer did not ask the witness to refrain from doing so. So you're required to elicit from the witness that the defense counsel did not act in an unethical manner?
That is the rule.
Does it make sense?
Yes.
Why?
And it is the rule.
Well, I understand it's the rule. I understand what Brown says, but my question is a little bit different. Should it continue to be the rule? I think that's what Judge Cowan is also inquiring. Should we make this a prerequisite to the admissibility of testimony that the prosecutor has to elicit from the witness what the defense counsel said to the witness? That's what Rule 4 seems to require.
Not going backwards, obviously, so it would not affect Mr. Hart in any way. Obviously, it could not be changed retroactively, but I think the question is directed to going forward.
I want to say I represent Mr. Hart. I would say going forward, so long as it doesn't affect my client, you must do as you please. I would say...
Well, no, that's not right. We have to do what the law requires,
Right.
not
What
as we
the-
please.
Yeah, the correct procedure in a case like this, where counsel is not asleep at the switch, is to have a voir dire outside the presence of the jury, where the Commonwealth proves by clear and convincing or beyond a reasonable doubt that these predicate factors were not met. Because obviously, if the defense lawyer said to him, "Don't you dare talk to the police," or if the defendant said to them, for instance, "I'll kill you if you talk to the police," that would be a factor that the court should be willing to consider. It ought not come in front of the jury. There ought to be a voir dire.
But what if the witness himself, as you say, many of the witnesses in this case knew that they should not, that it wasn't in their best interest to speak to the police?
It's a real problem, and that's why we have, I mean, in a practical sense, that's why we have voir dire, because this predicate is not something that the jury needs to hear. This is a predicate for admissibility. It's not a commentary on the weight of the evidence. It's a judicial requirement that these things be proved, and they don't have to be proved to the jury. They have to be proved to the judge, which here they were not. And in the absence of the proof to the judge, that's why it's not admissible, and the defense lawyer should have objected, and there should have been a voir dire outside, but everybody's asleep. That's the problem. And the fact that everybody's asleep is what allowed the prosecutor here to argue to the defendant's detriment and to the detriment of the right of everyone in the community not to speak to the police without drawing an inference of guilt against the defendant. The DA then gets to argue, well, if they were telling the truth, they would have come by themselves to the police station and talked to Bobby Murner, because that's what people do who are telling the truth. But that is not the case. Many people tell the truth, and they don't go alone to talk to Bobby Murner. And that's the situation that we have here. At least we have no proof otherwise.
Well, what I hear, maybe I'm hearing it correctly, but what I hear is that you're suggesting that this rule is somewhat outdated. I mean, Brown was a long time ago, I forget, probably early 80s. And what I hear you saying is that this fourth foundational question is somewhat outdated.
In practice, this doesn't arise. The language is outdated. What they're meaning to suggest, I think, by factor 4 in Brown is that not that the lawyer didn't specifically say you may not, but that the lawyer did not give the defendant to understand that it would not be helpful. That's really what they mean. They don't mean that the lawyer committed a breach of ethics. They meant that the witness, they know the witness isn't lying because the witness is just doing what the lawyer suggested is doable. And in practice, we don't see these cases because the voir dires happen outside the presence of the jury. That's how we're supposed to do it. So that, I think, is the answer.
Ms. Greenberg, your time is up.
Thank you, Judge.
Good morning. May it please the Court. John Zanini for the Commonwealth. We're asking you to affirm the first-degree murder conviction of the defendant Michael Hart for his murder of B. Othar Billingsley and his conviction of assault and battery and assault with intent to murder of Tanya Gibson.
In what way do you suggest that the fourth Brown factor was met here, Mr. Zanini? Your brief seems to skip over it, if I...
Yeah, that's fine. On page 29 of the Commonwealth's brief, I cite various cases, including Roberts and Gregory from this court, in which this court said that where there is no evidence on the record that the witness was instructed or asked not to come forward, where there's no evidence on the record, then the fourth factor, for all intents and purposes, is met. There is no preclusion from the cross-examination when there is that lack of evidence. And
So, in other words, from a negative, we can infer the positive, or that's what we've said.
Yes, and I...
Okay, what would your position be on if the fourth factor were changed somewhat, modernized, if you want, in some way that would comport more with current reality, and whether a voir dire should be held?
I don't think the voir dire is necessary because I think most of these factors in and of themselves are probably relevant and the jury ought to hear them because they do have a tendency sometimes to show, independently to show bias of a witness. I think it's in historical context, as the court noted, the Brown case itself is from the 80s, which the Brown case was actually tried just before the adoption of the rules. And prior to the adoption of the rules, there was no requirement for the notice of alibi to be provided to the Commonwealth. So the Brown case had a slightly different context to it. Now we have a notice of alibi requirement, which I think should and does change things. Also, the Brown case established the fourth factor, and the whole Brown case relies heavily on this case from New York, People v. Dawson, which is cited in Brown, and that's 50 New York 2nd 311 or 406 Northeast 2nd 771. I can send you a 16L letter, but it's cited directly in Brown. What Dawson actually says, there's a discussion in Dawson about this so-called fourth factor, and the way I understand Dawson is that having the witness asked and then answer about whether or not they were asked by someone not to come forward and not to speak is a relevant factor in and of itself for the jury to consider.
Mr. Zanini, to explore that a bit, in this case, the witnesses seem to have wanted to explain why they had not spoken to the police, and they were not allowed to, were they?
Well, I don't agree with that because, as the court knows, there is redirect examination, and during the redirect, they can certainly be asked exactly what their reasons were for not speaking to the police, including whether or not the defendant or his lawyer expressed a preference that they not speak to the police.
But isn't that incriminating by itself? I mean, why would a defense lawyer get up and say, did I tell you not to go to the police? That would be horrible in front of the jury.
I think that's worse from the question of the defendant's guilt.
Well, I don't think so, because what you're talking about is the credibility of the witness and whether or not the witness is proffering a false alibi. So if the witness says, well, the reason I didn't call Detective Murner back when he called my house, when he spoke to my husband, when he repeatedly tried to contact me, is because I had been asked to, not to call him back by the defendant himself.
Don't you? I mean, just
incredibly probative. right? That's consciousness of guilt by the defendant, so it's independently admissible on that basis. Setting that aside, the lawyer can't affirmatively ask or can't affirmatively instruct the witness not to speak. There's an ethical rule that's right on. He could if it was a relative and if it was not adverse to the witness's interest. I mean, it's SJC Rule 307, Rule 3.4.
Well,
fairness
given
to
that
opposing.
fact, doesn't that by itself suggest that this fourth factor is problematic?
It is. It should be eliminated entirely. I mean, it serves no purpose. It was never intended to be an exclusionary factor. I don't think any of these factors are intended to preclude or exclude cross-examination.
Well,
Brown itself says the judge retains discretion.
But
Yeah.
with a notice of alibi, does that argue in favor of leaving, there may be questions you can certainly ask the alibi witness that would probe his or her credibility and the reasons for the testimony, but because of the notice of alibi that needs to be given by the defense counsel, this whole idea about whether you spoke to the police or you did that or the other thing just seems to me it can be very damaging for the defendant, and it's not.
Well, damage does not mean unfair,
No, I mean,
prejudicial, or improper. In
I
fact,
meant
if the police have
implicitly unfair.
If the police have a notice of alibi and they try repeatedly to contact and speak with the witness, and the witness repeatedly avoids the police, that has a heavy tendency to show the bias of the witness in favor of the defendant and against the government.
Well, this case has unusual facts because of the efforts by the police to speak to this witness. Usually you don't have that. And also the rule applies to other things besides alibi, other information like, I have the gun, or I knew he didn't throw away the gun, or anything like that. You can ask the same, as long as you laid the proper foundation, you could ask the same questions. But so the rule has to be considered, I think, in a greater context than just alibi.
I would agree with that.
I don't think Brown was limited to just alibi, as I recall.
I understood it that way, but I would agree with
Maybe
you.
I
All of these
forget.
questions are probative of things other than the classic alibi, were you at home watching TV at the moment of the murder? But the Boston police, in my experience, are very, they do go out and try to talk to alibi witnesses. Our civilian investigators go out and try to talk to alibi witnesses. This is not unusual. We affirmatively reach out constantly and consistently to interview alibi witnesses. In fact, if you know of potential alibi
No, but if we
witnesses
write a
at the
rule,
outset,
we
you
write
try
it
to-
for, if we develop a change in the rule, it's for the whole state, and your police may go out and other police may not go out, and sometimes alibi witnesses come up at the last minute, and so it isn't possible
The
for them
fact
to
that
be
other
interviewed.
police don't go out and investigate shouldn't provide, some benefit to a defendant,
No, but
other
we
than the
have to-
fact that the police aren't out investigating.
Mr. Zanini, I'm curious about our case law that says, or it seems to say that these questions have to be asked, and a judge has no discretion to admit or to allow this line of cross-examination to continue. But what if a witness were to answer no to each one of these questions? A foreigner that happened to be visiting in the country didn't know anything at all, anything about exculpatory evidence, didn't know how to make the information available to the police, and was unfamiliar. Does that preclude the prosecutor from asking these questions?
No, it absolutely should not. I mean, all of that information is relevant to that witness's credibility.
It's
And
something that the
ought to
jury
hear
should
that.
hear.
Absolutely.
One way or the
That's-
other.
That's why I don't understand it, that Brown itself, I believe, says the judge retains discretion. So it's not a bright line rule. And the cases refer to this at times as guidelines. And I think all of these questions go to that witness's credibility. The jury ought to hear it. There's no reason to prevent the jury from hearing it. In fact, no case says that this is a voir dire outside the presence of the jury. We were discussing in the office. I said, well, what does it mean if you hit 3 out of 4 and you don't get the 4th in front of the jury, or somehow the witness says, oh, yeah, the defendant told me, hey, don't talk to the police. Does that mean that the judge then strikes the rest of it? Does it mean that you just can't argue it? Does it mean the judge gives an instruction and says something else to the jury? I mean, the jury should hear all of this, and it should be admissible. Every one of these questions and every one of these answers goes to the credibility of the witness and the veracity of the alibi. So I would suggest that all of this should come in front of the jury. All of it is admissible. All of it is permissible. Unless you want more on that question, I could turn to the second issue.
Well, before you leave that, do you say the source of this rule is constitutional in nature or simply to evaluate the relevance of the inference?
I think pre-disclosure of alibi, there was a sense of, there was some sense of, you can't order the defendant to disclose the alibi. I mean, I really didn't go back and think about it that way, but there was a sense that the defendant didn't have to disclose his alibi, and the oldest cases seem to me, or the Dawson case talks about this, and if you read the cross in Dawson, the witness is asked, well, why didn't you go to the grand jury? Sort of an absurd question. And the witness says, I don't know anything about any grand jury. What are you talking about? Which I think there's a sense of there's a little bit of a trick and an ambush there by a prosecutor on cross, which wasn't fair. So I think there's a sense of fairness behind the rule, but not a sense of constitutional infringement or constitutional right here. I don't think you have any. Once you have a notice of, the rules provide for reciprocal discovery. Once you have reciprocal discovery, you can then require the notice of alibi, and that protects the defendant's constitutional rights. Prior to that, there was a constitutional basis to rule that the defendant did not have to provide his alibi in advance because he didn't have so much discovery from the Commonwealth.
But the rule does, I'm pretty sure, I just looked up Brown, but it doesn't apply only to alibi evidence, and there's plenty of other evidence that someone could bring in, and there wouldn't be a rule covering it for notice.
Right.
So you've got to, any rule has to account for information about
think
whether
now with
somebody else
reciprocal-
had the gun or something like that.
I think with reciprocal discovery, you have to provide your witnesses, you have to provide their names, you have to provide your addresses.
But the defendant doesn't have to provide the substance of what the witness is going to say.
I agree, and that's why the police go out and try to interview these people.
And these
if
people
they're-
typically refuse. So, but what I'm saying is you can't just say that the rule that now governs notice of alibi takes care of the Brown problem, because it doesn't, because there's other information that the witness can possess that is not alibi evidence, exculpatory information.
I agree, but I think that weighs in favor of allowing the witness to be asked whether or not, isn't it true the police came to your house and knocked on your door? Isn't it true they called you? Isn't it true you refused to speak to the police?
Well, sure, that could be asked anyway. I mean, that's just typical cross-examination, but it doesn't go to the question of whether it's necessary to lay the foundation. And nor does notice of alibi help when it's this other type of evidence.
Right. I don't think it's a foundation. It shouldn't be a foundation outside the presence of the jury at all. Every one of these questions is relevant to a witness's bias and credibility. It should always be in front of the jury.
But I guess here's what's troubling me. I think what Ms. Greenberg is saying is that the reality is even a witness who is absolutely telling the truth about at least her perception that the defendant was elsewhere at the time of the murder, absolutely telling the truth, is not going to go to the police to say that for a variety of reasons that have nothing to do with lying, with credibility. So when you posit the question, well, you knew how to get to the police, all this stuff, it takes, it just puts a burden that may be unfair on the witness. I mean, it's damning the witness in credibility because the reality is, for a variety of reasons, that witness is not going to go to the police.
And all of that information will be in front of the jury. Because if the prosecutor doesn't elicit it, the defense lawyer will ask on redirect, well, miss, why didn't you go to the police? Well, I didn't go for the following reasons. I didn't want to incriminate myself. I don't like the police. I was previously arrested.
Oh, that's going to help. That's going to help the defense a lot. Any of those answers?
Well, they can explain to the jury what their reasons are for their behavior. And if their behavior includes, I took the murder weapon and I threw it in the river, they can explain that to the jury. If their behavior includes, oh yeah, he was with me watching a movie at the time of the rape or the murder or the robbery, then they can explain to the jury why it was when the police knocked on their door the next day.
That's a different question.
They didn't talk.
That's fair game.
But these are the questions. These are the Brown questions.
In this case, I appreciate that.
No, in every Brown case. In every case, these are the questions. Do you know the defendant? Are you friendly to the defendant? Did you know he was charged with a crime? Did you have some information that was going to help him out? Did you know that the police wanted to talk to you? Or did you know how to go provide that information to the DA or the police? All of it is relevant for the jury to assess the credibility of that witness. So there should be no preclusion here. To the extent it's been read that way, you should clarify it and say, these questions are all fair game.
You had said that the notice of alibi changes the substance of Brown, or should change the substance of Brown. What do you mean by that?
Well, I was just trying to address your question whether it was a constitutional basis, and thinking about the issue in Brown where the prosecutor asked, why didn't you didn't go to the grand jury, did you? That there was a sense that there was something unfair there in what was going on. And a lot of the unfairness, the sense of unfairness in criminal trials, where people used to not have a lot of reciprocal discovery, is all ameliorated by the reciprocal discovery rule. And once you do that and include the alibi, what's the purpose of telling the prosecutor, for instance, gee, I have a witness, and here's the name, here's the address, and here's the phone number. If you tell the witness, and by the way, we'd really like it if you really didn't talk to the prosecutor or the police officer, and you can't let the jury know that the reason that the police, you could certainly ask the officer in terms of the scope of the investigation, did you knock on this witness's door every day for a week? I did. And what happened? The curtains moved and nobody came out. Did you call every day? I called every day. Did you talk to her husband? I talked to her husband. So whatever unfairness there might be before the reciprocal discovery rules, once you have that notice of alibi, it doesn't serve any purpose if you can't tell the jury. We knew about the alibi. We went to talk to all the witnesses. None of them would talk to us. They were all following a code of silence, maybe. Let the jury assess that, because that goes to their credibility. And the witness can explain whatever their reason was. On the second issue, as you know, this interplays with the first issue, because the second issue was the prosecutor sent a trial subpoena to the Plymouth County Sheriff and said, can we please have the recordings of the phone calls this person made, the defendant here, and that she disclosed when the prosecutor got those, it said there was in lieu of showing up at the courthouse, you can give me the recordings at my office. She made a copy. She disclosed them all to the defendant's lawyer. That's clear, and I have the transcript cites in the brief. He had all of those at the outset of the trial. She got them shortly before the trial. As she said, the reason that I did this was because of the alibi, and we're looking into the alibi and rebutting the alibi. The judge then says, all right, well, if you want to use any particular call, narrow it down, give the defense lawyer a transcript. We'll revisit when we get to the rebuttal part or the cross-exam part of the case. At that point, she says, I've identified 6 calls. They ultimately narrow it down to 2 calls. The defense lawyer has transcripts. He acknowledges he's listened to them. He acknowledges that the defendant was told on the tapes this call is being recorded. So this is a call that the sheriff makes, that the sheriff has. It's in the custody and control of the sheriff because it's the Plymouth County Sheriff's tape. It's his property. The defendant, or any defendant who leaves the place of detainment, when they check out and sign out all their property, they never say, and by the way, can I have my tapes? They could probably have a copy if they wanted one. But she gets these. Everybody knows about it. The defense lawyer knows about it. They go to exactly the 2 calls she's going to use. Those 2 calls are between the defendant and his sister. He's talking about these 2 alibi witnesses. They talk about straightening it out, and they talk about the exact time, 11:09 p.m. The comment I think the sister made was, we're not stupid. We know it's 11:09 p.m. So it's clear that they are, one inference you can draw is that they are concocting or fabricating an alibi. And I would suggest that that's highly admissible and probative. It also goes back to the Brown issue of, gee, can I cross-examine these witnesses about why they were avoiding the police when I have affirmative evidence that the defendant was actually getting these people to engage in concocting a false alibi? And I think once you have affirmative evidence of a false alibi, you can sort of say, well, why do we have Brown? I mean,
I-
it doesn't serve any purpose at that point.
Maybe I'm missing something, but when I read the 2 phone calls, I don't see that they're all that incriminating. I mean, the worst thing is that Spot says, oh, we know what time it is. Ain't nobody stupid, we know what time it is.
Right.
But so that's why is that mean that he's talking
Not-
about
not
an
just reading it.
illegitimate alibi?
Well, it doesn't, but that's an inference for a jury to draw, isn't it? I mean,
And
that's
then-
why we have juries, is to figure out and draw inferences. And she doesn't just say, we're not stupid. She says, I know that at 11:09, he was at the house.
Okay, so.
She's saying this
so-
to her brother on the phone.
So, I
Right?
mean, I don't see what's incriminating about that.
Well, it's an inference for the jury to draw whether or not these people are concocting a false alibi, or whether the other inference is maybe they're just confirming what the actual
truth.
state of events was. But that's for the jury to hear. And in addition to that, you have alibi witnesses who, for whatever reason, refuse to talk to the police, refuse to answer phone calls, refuse to speak with the police at all. So the jury can draw the inference whether or not that was an incriminating call, whether or not they were concocting a false alibi.
Does the record indicate whether or not the sheriff or anybody in the department, the sheriff's department, listened to any of these tapes?
There is no indication on the record, and of course it's irrelevant. And it's irrelevant because, as defense counsel pointed out in her 16L letter when she cited the practice manual for criminal defense, there's this Bolero case, 349 Mass 505, where they talk about going into interview witnesses, the witnesses belong to neither side, and the court, whether or not there's a fishing expedition going on, the court says, pejoratives of this sort are no answer. It is too plain to be labored that the interviewing of prospective witnesses is an essential part of the preparation of a case for trial. Listening to those tapes that are already made, that are already lawfully in possession and custody of the sheriff, that are already the possession and custody of the government, they're the government's case, listening to those tapes is just an essential part of preparation for trial. It's no different than going and interviewing a witness. Those are the government's tapes. To not listen to them, in fact, would really be a misstep by any prosecutor in any case, I think. But we don't have to get that broad here. It's clear this was relevant evidence.
Your time is up. Thank you.
Thank you.
SJC 8986 Commonwealth versus Shop.